Here are 3 things a good lawyer should do for you if you've been charged with a DUI based upon the result of a breathalyzer test. I'm Eugene Cisco. I have over 20 years experience both as a prosecutor and a criminal defense attorney, and I have been a part of countless DUI cases. After an officer has stopped you and developed their probable cause to arrest you on suspicion for DUI, they'll most likely take you to a processing center where they will ask your consent to either draw blood or take a breath test. If you're given the choice between breath and blood, I'll take the breath test every time. Blood tests are highly reliable and are almost impossible to challenge in a court of law. While the government claims the breath test is a highly sophisticated and reliable machine, it has a host of problems that can be challenged by a good attorney. So let's get into my top 3 breathalyzer challenges. Number 1, the breathalyzer must be maintained regularly. Failure to maintain that breathalyzer in a proper fashion could render those results unreliable. Number 2, there is a mandatory 20-minute wait period in which you must be observed by an officer or a certified personnel prior to administering you that test. Many of these facilities have time-stamped cameras. Either you or your attorney should file a motion and request that facility give you a copy of that time-stamped video. And number 3, that breathalyzer is a highly specialized and sophisticated piece of machinery. The individual that operated the breathalyzer that you took needs to be certified and trained on that particular machine. Because that officer may have been trained on other machines within that facility does not mean that they were trained on the particular machine that you used. Failure to meet those qualifications and guidelines could render your test inadmissible. If you like this information and found it helpful, go ahead and click that follow button for more.